Welcome everybody. My name is Chris Gough. I'm a partner at Mills Reeve in Birmingham and I head our casualty injury team. I'm going to be speaking to you this morning essentially about when injury claims go wrong. The session is being recorded. Whilst you can see me, I can't see you. So everybody in hoodies and pajamas is quite safe. There's going to be an opportunity for some questions and answers at the end. Please do post your questions into the chat box as I go along. My colleague Harriet Strevens will coordinate the questions and we'll deal with those at the end of the seminar. Or if we don't have time, we can pick up on those by email. So if we move on then to the agenda, we'll set the scene, we'll look at some tactics, and we'll try and level a playing field in the claims context. So what do we mean about claims going wrong? It's a question of when a claim turns into something that we didn't necessarily think it was. The skill and the focus of the claims adjuster in the claims office is to try and bring certainty to the matter. But if a claim changes or our understanding of the claim changes, we can reach a point where we don't have any evidence to challenge it. We're about to get a massive award of damages and costs that nobody's budgeted for. And in a hardening insurance market, maintaining the good claims history, keeping control of the claim, and spotting and avoiding the banana skins that can sometimes cause these big surprises and essentially spikes in the reserve are truly significant and important to track. Now, there's a caveat that I need to share, which is that many opponents are entirely focused on engaging, being transparent, securing a fair outcome for their client at the earliest appropriate opportunity. At the same time, what we're about to consider is not a reflection on all legal practitioners, but, and you don't need to comment watching the webinar now, lawyers don't always act in a way that boosts their reputation, so shall we say. So we're going to use a case study just to set the scene now. And this is drawn from some Mills Reeve experience. Jeff and Roscoe construction, we'll call it. But the claimant in this case was an agency supplied site manager to a construction site, had a very minor accident in December 2013, had a minor collision between the bucket of a digger and his shoulder. He got back up, dusted himself off, carried on working, didn't take any time off that day, finished the next 3 months of his contract on site with no apparent ill effects, no complaints to anybody, and was never seen again or heard of until about 18 months later, a letter of claim was submitted. It looked very much like a modest shoulder injury based on that letter of claim. Obviously, the site had been closed by then, the construction work had been finished, there was no active investigation, and based on allegations of vicarious liability on the part of the digger driver, an admission of liability was made. Scroll forwards to the issue of proceedings. This is the first time then, 3 years later and another 4 months later, when the defendant first sees any medical evidence. There's not just one, there are 2 orthopedic reports, there's a psychiatric report, and there's a schedule of loss pleading damages in excess of £1 million. So very quickly, the shape of this claim has changed drastically, and it's at a time when it's far too late for the defendant potentially to do a great deal about it. So as you can see there, the defendant's on the back foot, and for those sorts of reasons that I've described, we're facing some serious concern around reserving. Claims manager is extremely concerned. The insured would be extremely concerned if they hadn't already gone into liquidation, which was another issue there for the sake of investigating the claim. And this is what we mean by an injury claim going wrong. So there are terms within the personal injury pre-action protocol that are designed to mitigate against that sort of eventuality. The PAP is there to encourage early engagement, transparency, sharing of information, clarity of allegations, and ideally to enable the parties to avoid litigation. The letter of claim has some prescribed content according to the preaction protocol, and that's referred to on the screen. But of course, the difficulty is we don't always get that level of detail. And the sanctions that are there within the preaction protocol don't actually take effect until after proceedings are issued. So it can sometimes be 6 or 9 months into proceedings before we can highlight that sort of conduct with the court. So a question for the audience now, and I think you'll be able to vote on this, but if making effective decisions and early decisions and well-judged offers of settlement enables the defendant to protect itself from the risk of paying more in costs, what sort of impact is that likely to have commercially for the claimant's solicitors? The early settlement is potential, well, according to the audience, and thank you for responding there, early settlement in some respects is likely to be advantageous. Around 35% of you reflect on that. 12% see it as neutral. 52%, a majority, but a significant majority, would anticipate that early settlement would be commercially damaging to the claimant's solicitors. And I think that's a fair summary of the reality. If a claimant's practice is efficient, they can churn and burn, they can make good profit on efficient case handling. But and as I said, it's not all claimant lawyers will tend to try and obfuscate, increase the risk, increase the time it takes to get to grips with a case, and increase their costs and profit along the way. So it's a fair summary then to say that there may be some rationale for the claimant treating the defendant like a mushroom. Smoke and mirrors can make it hard to identify the real nature of the claim. And if we can't pin the claim down in terms of its value, we might make bad decisions in how we conduct the defence. Slow decisions, poor decisions, underestimates on value all allow a claim to proceed unnecessarily and for costs to be incurred. The claim at the end of the day is still going to be the claim, but it's taking longer to get to grips with it and to set our strategy and put the claimant on the back foot. Some of the tactics that we see then include things, even in the current climate of the pandemic, as simple as sending a letter of claim by post or a CNF by post to an office that is probably going to be closed during lockdown. That's enough to see a claim fall out of the portal potentially in terms of a delay in responding to it, might move on to predictive costs, may ultimately move on to standard costs and be more remunerative for the claimant's solicitors. Equally minimising the accuracy and detail in the CNF or letter of claim. And as referred to in the case study at the beginning of the webinar, holding back on medical evidence. We have to think about whether the understanding the claims adjuster has of the seriousness of the injury, if that is incomplete or unclear, what sort of approach might that encourage in terms of claims handling and the liability decision in particular? So there's options A, B, and C. Once again, if people would like to make their votes, and we'll see the results of the poll in a moment. Interesting, thank you. We've got the guts of 57 towards 60% of people thinking that they would judge each case on its merit and wouldn't be influenced by the potential value of the claim. Only 11% are driven by cycle times and settlement ratios, and 31% would anticipate proportionality and commerciality being factors in their decision making, which is really encouraging because we've got an audience who are clearly prepared to make robust decisions about liability that aren't dependent on the value of the claim. Contradicts the example in the case study where a light touch decision was made on liability, but it's interesting and valuable feedback. Thank you. We've paused and reflected on that sort of scenario, claimant keeping us guessing about quantum, possibly drawing out commercial admissions, and the concern there is that they'd be incredibly difficult to draw back from. Resiling from an admission of liability is rarely successful, even in the face of multi-million-pound claims relative to the claim that perhaps we thought we were first dealing with. So that's something to be really aware of. So how do we try and redress the balance and start to push back in a claim where we're not really getting the level of engagement we should be. And it can begin, and I know there are a lot of brokers on the webinar this morning, but it can begin with encouraging the insured to have a proactive health and safety policy, and one that is incorporated into the terms of employment, and that an employee is required to follow that health and safety policy, which includes a provision that they should cooperate with any investigation of an accident. And that's an entirely reasonable thing for an employer to propose, but it gives a contractual expectation that a claimant, an injured party, is going to give a frank account of what happened, and that's the starting point of a good investigation. Building on that, getting the names, contact numbers and accounts from any witnesses, and capturing all that information and the relevant documents in a way that is useful and easily accessed in future, creating a bundle, a PDF that would preempt a request for pre-action disclosure would be a hugely useful thing to do. Equally, during the claim handling process, we need to try and pay attention and keep some regard for what might be regarded as red flags, and these are the subtler elements that might encourage us to dig a bit deeper and think a bit harder about what may be going on behind the scenes. And it can be things like nobody else saw the accident, or the accident wasn't reported at the time by the claimant. The story has changed over the weeks, months and years, depending on who the claimant was telling it to, whether in the accident report form, to the GP, to a supervisor, to a medical expert. Also, if we're dealing with a claim from a transient worker, and by that it might be, as in the case study, an agency worker, a contractor who might work on half a dozen different sites a year, but already that should be triggering a degree of interest, because that's somebody who's going to be difficult to track, both in terms of pre-accident employment history and post-accident employment history, and creates an opportunity for confusion and uncertainty if our opponents want to play it that way. Obviously, thinking about injury types, and some very serious injuries are always going to attract the right kind of attention, but thinking more subtly, any injury to a dominant hand, anybody in a manual labour occupation, those sorts of things. Looking at the absence-related position as well, if it was an innocuous injury but somebody's had a disproportionate amount of time off, and essentially anybody who's had more than 6 months off work is hugely less likely to ever actually return to work. But we can measure that 6 months post-accident. We should be making those inquiries of the insured or the claimant's solicitors and challenging any reluctance to engage with us. So we look at, as preface there, trying to develop better lines of sight, trying to claim the evidential high ground, and doing that with perhaps an early desktop investigation, pinpointing telephone numbers, contact details, and actually following through on those discussions with witnesses. In the case study, 4 years post-accident, I was able to interview the digger driver, who gave us a very different account of the accident to the one that the claimant had given, for example. Think about what are the relationships the claimant has outside of the claim scenario, previous employers, subsequent employers, or if he's still employed with the same insured, what do we know about his sickness absence? What do we know about his subsequent conduct? What about his pastimes and interests? A bit more background on the person we're dealing with. And all the time we're looking for independent and verifiable sources of information, because that's how we create evidence that we can use to put in play in the claim pre-action or in litigation to actually challenge some of the claimant's account. It's not all a one-sided conversation. And in some cases it's a reference out to a field adjuster, or even in potentially higher value cases where it's proportionate, a referral out to panel and an early investigation with the defendant's solicitor. The danger then is that we're faced with a welter of information. If we do access records, if we do access employment histories, if we do access social media, all those different sources, how do we assimilate it? How do we make sense of it? And the first and last word on that is the chronology. Taking the time to put all of that data into chronological order will help identify trends, patterns of behavior, areas of interest and activity outside of the claims context, and perhaps even trends in terms of medical history and recurrent illnesses or competing causational factors, all of which may be grounds for seeking permission for a unilateral medical report some way down the line. So having done some of that digging and challenging and found those independent sources of information, we've backfilled a void, and how do we take advantage of it? It may be that there really isn't a great deal we can do, because part of our answer may be that liability is disputed, we're not making any offers, and it's a waiting game for proceedings and the opportunity to challenge the claim at that point. We can always flag the claimant's conduct in correspondence with them and say it's something we're going to highlight with the court. If they've been coy, they've used a bit of a veil to keep the claimant behind. But in those cases where liability is being admitted, be bold, make offers, go on the front foot in terms of trying to create some risk and put the claimant under pressure. Equally, always look for moments where the claimant is seeking something from us, and principally that involves interim payments. But make sure we leverage them. If the claimant wants £5,000 from us, what about disclosing all the medical evidence he's got to date? What about supplying us with mandates for those medical records that we've been asking for? We may not object to giving a £5,000 interim voluntarily, but we can add conditions to it. And also, perhaps most boldly, consider the cost that it's going to take to defend the claim to trial potentially. If it's not a fraud case, if there aren't any other grounds to disapply quocs, those are going to be costs that we're going to incur anyway. Do we want to think about taking some of that expenditure and try and use it very early in the process to make a significant offer, put the claimant at risk, and perhaps conclude the claim? So we'll move on now to the moment where, I don't know if people have been submitting questions through the chat box, but Harriet Strevens will coordinate that for us, and I'll try and deal with them for you.
Thank you very much, Chris. We have a couple of questions, but we're running a bit short of time this morning, so I'm going to limit them to only two. If the preaction protocol is a toothless tiger, just when is it that any sort of this behaviour you've spoken about might trigger some sort of sanction?
It's a good one, Harriet. Thank you, and thank you for whoever's suggested that. The moment when claimant's pre-action conduct is really first going to be ventilated before the court is at the first case management conference. And that's the point where directions will be set for the future conduct. The nature of the claim will be considered, the value of the claim will be considered, and a proportionate view on case management will be taken. But the defendant may want to say at that point, all of what's happened so far hasn't been adequate. We've only really identified what this claim is about on the issue of proceedings. We may want to seek a stay while we take stock, gather further evidence, or make cost offers, and just pause the proceedings there while we try and put the claimant back under some pressure.
Thank you, Chris. My second question talks about early admissions. Do you not think it's difficult to achieve this, not least because the insured may not want to consider this until it's fully understood the claimant's case, or more usually wants to fight and have its day in court, assuming it's got a strong defence?
Well, we know that the admission of liability, if that is appropriate, can be an incredibly sensitive moment for the insured. They can be very invested in the scenario. They can have very strong views. And that's always an important relationship to manage constructively with help from the broker. It should always be viewed as a tripartite conversation between the adjuster, the insured, and solicitor or whom else is advising. But if the information is there early, the rationale for the admission should be evident, and there should be some engagement and collective buy-in from all those stakeholders.
So in effect, what you're saying is good communication is the key, I guess.
Thank you, Harriet. That's what I was trying to say.
Not at all. I'm afraid we've run out of time, so I'm going to pass back to you, if I may, to close up. Thank you.
Okay, well, thank you, everybody, for taking the time this morning to listen and view our next Cover Talk webinar. You don't have long to wait. It's going to be hugely engaging and interesting. The FCA test case is a huge development. My colleagues Ben and Charlie will be doing that for you towards the beginning of February. it's my opportunity now just to say thank you to everybody who took the time this morning to view with us, and also to Harriet and to Leanne, without whose assistance in preparing for this morning, it wouldn't have gone as smoothly as it has, shall we say. But thank you, everybody, and I hope you've enjoyed it.